I knew it was too good to be true, and it was. Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, and your number one source for everything It Ends With Us saga. I am drained, and the saga is sad today. As I have been sharing with you all, litigious live me made me the latest victim. As I have shared with you all, litigious lively made me one of her many victims of a subpoena. Her legal team sent out over 107 subpoenas just to journalist creators. Folks whose content you probably enjoy. Over 107 journalist creators. The one issued against me listed Las Vegas as the place of compliance. That's where I live, that's where I work, and that's where I already filed my motion to quash. And I have made a procedural mistake. And don't worry, I'm down, but I'm not out. And this video is good. This video has some hot tea that you will probably freak out over when we get to that part. I'll let you know when. So, as I excitedly told you yesterday, the court here in Las Vegas, the correct venue to litigate her, I think, unenforceable, unethical subpoena, asking for my sources, which are privileged and protected by the law because I am a reporter, the court had issued a date to reply by. That date was Monday, August 11th. Monday, August 11th came and went, and there was no opposition or response whatsoever. So, yesterday, I submitted a notice regarding non-opposition to motion to quash and request for motion to be granted. I cited a rule saying under Local Rule 72D, the failure of an opposing party to file points and authorities in response to a motion constitutes a consent to the granting of the motion. So it made sense to me that my motion to quash the subpoena be granted. But the judge disagreed. Here's why. Judge Richard F. Boulware II issued the following order yesterday in response to my request. He writes, "This action was commenced by Mario Lavandera Jr., a.k.a. P to the E to the R to the E to the Z, H to the I to the L to the T to the O to the N, Hilton, filing the motion to quash subpoena. The subject subpoena was served on Hilton, issued by the United States District Court for the Southern District of New York, in Blake Lively versus Wayfarer Studios, LLC, and signed by Michael Gottlieb on behalf of Blake Lively, the plaintiff in the underlying action. Compliance is required in this district." Wait a minute. Maybe I should submit this to Judge Lyman, saying that he just stated compliance is required in that district. Oh my God. This actually is a blessing. I made a mistake procedurally, but this is a blessing. The judge in Las Vegas, Judge Boulware, says, compliance is required in this district, meaning Nevada. The CMECF e-filing software automatically indicated a response deadline of August 11th, 2025, when the motion to quash was docketed on July 28th, 2025. I thought that was the judge saying that, but no, the system did it automatically. On August 4th, 2025, Hilton filed the proof of service, which is an unauthenticated document purporting to attach an email chain between Hilton and an attorney, Ezra Hudson. There is no indication in the document as to when Hilton claims to have sent the motion to quash to Ezra Hudson, nor what relation Ezra Hudson has to Blake Lively. On August the 12th, 2025, Hilton filed a notice of non-opposition, which indicates Hilton misinterpreted the automatic docket text setting a response deadline of August 11th, 2025 as an order of this court. The notice requests the motion to quash be granted as unopposed pursuant to Local Rule 7-2. The court finds this insufficient to establish proper service of the motion to quash under Federal Rules of Civil Procedure 5 and Local Rule 5-1. Therefore, it is hereby ordered that on or before August 19th, 2025, Hilton must serve a copy of the motion to quash on Blake Lively's counsel, Michael Gottlieb, pursuant to Federal Rule of Civil Procedure 5B and Local Rule 5-1. It is further ordered that on or before August 19th, 2025, Hilton must file a certificate of service which specifies the date as well as the manner of service using this court's approved certificate of service form, which can be found at, and then the judge kindly included the link. It is further ordered that Blake Lively's response to the motion is due 14 days after proper service, consistent with this order. Copies have been distributed pursuant to the NEFIML. As you guys know, I am handling this all without an attorney because I'm not being sued. It's just a subpoena. And to fight this, it would cost tens of thousands of dollars. I don't want to waste tens of thousands of dollars on her and this. I do want to fight this because I don't believe it is right, and I do believe I am correct in my assertion that what she's asking of me is privileged and protected information. So I'm gonna make mistakes, and I just did. I made two. I incorrectly interpreted the August 11th as being an order of the court. It was done automatically. And I incorrectly believed that letting her team know by email that I filed this motion to quash in Las Vegas was sufficient and appropriate. It was not. So I have acted quickly and stood on business and taken care of this already. The judge kindly gave me until next week. I don't want to waste time. Let's get this going. But at the end of the day, all that's happened here is a delay, a pause. And that's fine. I'm not in a hurry to wrap this up. I want to tap out. I really want to be done with this, but this is just a little speed bump, a blip. as I said, a delay. Nothing huge. Not a major setback, a minor one. Okay? So, this is my response back to the judge. Dated today, it says, Certificate of Service, Most Honorable Judge Boulware. I, Mario Armando Lavandeira Jr., known professionally as P to the E to the R to the E to the Z, H to the I to the L to the T to the O to the N, write in response to your order dated August 12th, 2025, in connection to, then the case name here in Las Vegas, which is Inri Mario Lavandeira Jr., and then the case number, docket number 9. I would like to submit a certificate of service that is in accordance with this court's guidelines. See Exhibit A. I thank Your Honor for guiding me to the correct certificate of service form that this court uses. I am representing myself without a lawyer in my motion to quash this subpoena, and as a pro se movant, I am sincerely working to the best of my abilities to abide by all the court's guidelines and in the manner that is expected. To clarify the record, Ms. Ezra Hudson is one of the lawyers representing Ms. Lively with regards to her current litigation, which I am a non-party to. I had already been in communication with Ms. Hudson about other matters, so I emailed her a copy of the motion to quash on August 2nd, 2025, and Mr. Gottlieb was CC'd. See Exhibit B. I regret that when I initially submitted to this court a copy of the email referenced above, the top part of the PDF filing did not have any information showing. I am still unsure why this is happening, but I have figured out a workaround for Exhibit B and further email filings. And if anybody can help me troubleshoot this in the comments, it would be so appreciated. I don't know why, but I go to the email, I click print, I then tap out, and that turns it into a PDF. But the top of my email and all of the CC'd information isn't showing up when I create a PDF that way. It did work in the past, but it stopped working. I don't know why. So the workaround that I figured was forwarding the email to myself. So I forward the email to myself, I received it, and then I was able to turn that email into a PDF showing a true and accurate reflection of what transpired in those email communications. Oh my God. I also tell this judge in Las Vegas, Mr. Gottlieb and Ms. Hudson can confirm to Your Honor that I did email them on August 2nd and that the motion to quash filed in this court was attached. I would like to humbly apologize for not knowing that serving the motion to quash via email was unacceptable. That has been remedied today, as I have sent Mr. Gottlieb, as instructed, all of the requested filings. I not only certify that this has been done to his address of record as detailed in the certificate of service form I have just filed, but I am also submitting a receipt that proves these materials were sent today to Mr. Gottlieb by delivery service, with signature required. See Exhibit C, a copy of my receipt to mail the motion to quash and related filings. Additionally, Mr. Gottlieb and Miss Hudson were aware of my motion to quash in this court. In fact, Miss Hudson emailed me on August 6th, 2025, about the action Your Honor is overseeing here, with Mr. Gottlieb on CC. See Exhibit D. Honey child, Exhibit D is where it gets juicy. On August the 6th, her lawyer wrote me saying, "Dear Mr. Hilton, yesterday we filed our opposition to your motion for a protective order in Lively v. Wayfarer Studios, LLC, case number, blah, blah, the Southern District of New York. Please find attached for service the full set of filings submitted to the court, as well as the court's order dated today and the protective order entered in the case. Pursuant to the court's order, we are providing you the sealed, confidential copies of documents containing information." I cannot reveal this next part because that is confidential. Actually, this part is not confidential. Only the attached sealed documents are confidential. I just reread this and wanted to make sure. And also, I'm submitting this to the court in Nevada, so it's going to hit the public docket. Pursuant to the court's order, we are providing you the sealed, confidential copies of documents containing information the Wayfarer parties, not Miss Lively, have designated as confidential. I have not and will not reveal anything designated as confidential. Haven't even made a joke about that. That's not happened, and it will not happen. Then we jump to this part. As you will see, because your motion sought relief related to the subpoena from the Southern District of New York, we have cross-moved to compel your compliance with the subpoena in the opposition. We've also had the chance to review the motion to quash that you filed in the District of Nevada, including your position that Miss Lively should seek to obtain responsive documents directly from the Wayfarer defendants first, before seeking them from you. Relatedly, you also may have seen that the court on Monday entered an order with respect to Mr. Friedman's law firm, Liner, holding that communications in the possession of a party's attorney may be considered to be within the control of the party, and that if Mr. Friedman made a written communication to a content creator or to a journalist to shape communications on behalf of the Wayfarer parties or within the scope of the representation, and if the Wayfarer parties asked for a copy of that communication, Liner would provide it to the Wayfarer parties. On the same day, our client filed a motion to compel the Wayfarer parties to provide all communications sent by their agents or on their behalf. Given these developments, we seem to be on the same page that the Wayfarer defendants should produce these documents in the first instance. As a result, we propose to pause our cross motion to compel in SDNY and request that you pause your motion to quash in Nevada, while the court in SDNY sorts out our motion to compel as to the Wayfarer defendants. It may be that the court's decision on that will make both of our motions moot. If this makes sense to you, we could submit something jointly in SDNY and Nevada asking for our respective motions to be held in abeyance pending the court's decision in SDNY on our motion to compel. We'd be happy to prepare it for your consideration. On a procedural note, you attempted to serve the Nevada motion to quash via email. We would be willing to agree to accept service via email with the date of service being Monday, August 4th, 2025. Please let us know if we have an agreement, and you can advise the court of your service of the motion via counsel by agreement. Please let me know your thoughts on this approach. Thanks in advance. Ezra was being so friendly here. That obviously set off some red flags for me. But I am drained. I've been drained. I am not wanting to be a part of this anymore. So this seemed like a sensible offer to me. Okay. She was just saying, let's both take a pause. All right, no harm, no foul. A pause for both of us seems needed, for me at least. That seems great. So the next day, ethically challenged Ezra sent me a proposed joint stipulation. It proposed to say the following. It is hereby stipulated and agreed by and among Miss Lively and Mr. Hilton that 1. Miss Lively's cross motion to compel as to Mr. Hilton should be held in abeyance until the court's decision on Miss Lively's motion to compel against the Wayfarer parties. 2. Mr. Hilton and Miss Lively shall file a stipulation in the United States District Court for the District of Nevada, agreeing to also hold Mr. Hilton's motion to quash the subpoena in abeyance until the court's decision on Miss Lively's motion to compel against the Wayfarer parties. 3. All obligations of Miss Lively and Mr. Hilton to oppose or reply to the cross motion to compel or the motion to quash, respectively, should be suspended during the period of abeyance. 4. Nothing in this stipulation shall be construed as a waiver of any rights, arguments, or defenses of either party, including all positions as to proper venue. So, I had not agreed to this, but I said I was open to it. My initial thought was, this sounds okay. However, after reading the proposed joint stipulation, I emailed over some changes that I wanted, that I needed. I said a few points I would like included in this for discussion. 1, no new discovery. During the abeyance period, Miss Lively, her counsel, and their agents shall not serve or pursue any new subpoenas, document requests, or other discovery directed at Mr. Hilton in any forum. 2, I wanted stronger language on this. 2, preservation of venue and jurisdiction objections. Nothing in this stipulation shall be construed as a waiver by Mr. Hilton of any rights, arguments, or defenses, including his position that the United States District Court for the District of Nevada is the sole and proper venue for resolving disputes regarding the subpoena. Miss Lively expressly agrees not to argue that Mr. Hilton has consented to SDNY jurisdiction over his Nevada-filed motion to quash by entering into this stipulation. Very sensible, right? And 3, I said, no prejudicial effect of Wayfarer ruling. The parties agree that any ruling on Miss Lively's motion to compel against the Wayfarer parties shall not by itself be deemed determinative of the merits of Mr. Hilton's motion to quash or any objections he has raised, and shall not be used to assert waiver or estoppel against Mr. Hilton. My gut kept telling me that this compromise, this agreement, this joint abeyance, it felt like they were somehow trying to get me, like a trap. So I was just trying to protect myself. And Ezra stopped responding. I'm assuming, because this was many days ago now, the offer is now off the table. And that's okay. Because now, because of my procedural mistake, this whole process in Las Vegas is going to be delayed anyways. But remember what I said earlier. This mistake turned out to be a blessing. So now back to my letter to the judge in Las Vegas. I tell Judge Boulware, quote, also on August 6th, 2025, Miss Lively's counsel informed the Honorable Judge Lyman of the Southern District of New York that she would be responding to my motion to quash in your court, which is the correct venue to litigate issues regarding this subpoena. See Exhibit E. Footnote number 19 states, quote, the motion Mr. Hilton filed in Nevada has an ECF stamp of July 28, 2025, but he did not purport to serve counsel for Miss Lively until August 2nd, 2025. Mr. Hilton filed notice of the Nevada filing on this court's docket with a transaction date for the payment of filing fees of July 31st, 2025. Either way, Miss Lively intends to file an opposition in Nevada by August 18th, 2025, as the rules require, and to request that court transfer the matter here for purposes of judicial economy, unless this court has entered an order rendering that filing moot. Then, after quoting Team Delulu, I tell the Nevada judge, quote, Las Vegas is where I live, where I work, where I was served, and where Miss Lively's subpoena lists as the place of compliance. Your Honor's court is the correct and only venue to litigate issues regarding this subpoena. It is my truest wish that going forward, I make no further procedural errors, and I express my deepest gratitude to Your Honor for your understanding as I navigate this process against a very famous celebrity with unlimited financial resources and extremely expensive lawyers. I am working hard to make sure I do everything appropriately in these proceedings, and I'm taking this all very seriously. Respectfully submitted with humility and sincerity, Mario Armando Lavandera, Jr. So, you got some tea and I got but also so this video was, oh my God. I started down, but I'm ending this video up. Yay! I'm already liking this judge in Las Vegas a lot. Okay, my fam, thoughts? Anything, everything? Let's discuss it all in the comment section.